Tonight, we are very excited to welcome Lisa Graves to talk about her book, Without Precedent. In the last 20 years, the U.S. Supreme Court has curtailed voting rights, undermined anti-corruption measures, failed to address political gerrymandering, rolled back restrictions on guns, and overturned Roe v. Wade. This transformation has been led by Chief Justice John Roberts. In the last 20 years, the U.S. Supreme Court has been transformed, as I said, by Chief Justice Roberts. Without Precedent dismantles the myth that Roberts is a fair-minded institutionalist who works to blunt the worst impulses of other Republican appointees to the court. Informed by the author's experience working on judicial issues for all three branches of the federal government and based on years of research, the book exposes Chief Justice Roberts as, in effect, a politician in robes and offers a plan for judicial reform to correct the shortcomings of the court. Graves draws on her years observing the Beltway's excesses to chart how Roberts has used his influence to check boxes of the to-do list of a cadre of far-right jurists and donors. Graves, a graduate of Cornell Law School, is a former chief counsel for nominations for the Senate Judiciary Committee and the founder and executive director of True North Research, a national investigative watchdog group. She is the former executive director of the Center for Media and Democracy. She resides in Superior, Wisconsin. Graves will be in conversation with Senator Sheldon Whitehouse of Rhode Island. Senator Whitehouse is the author of 2 books on the influence of corporate and dark money interests on American democracy. He has been at the center of bipartisan efforts to pass laws overhauling federal education policy, rebuilding our nation's infrastructure, reforming the criminal and juvenile justice systems, protecting Americans from toxic chemicals in everyday products, and addressing ocean plastic waste. A graduate of Yale University and the University of Virginia School of Law, Senator Whitehouse served as Rhode Island's United States Attorney and State Attorney General before being elected to the Senate in 2006. Without further ado, please welcome the author and Senator Whitehouse.
Well. Is this actually operational? Yes, it is. I hear it echoing. Well, good afternoon, everyone. It's a treat for me to be here with one of my heroes, Lisa Graves. And my 2-minute introduction is that we, in my view, our democracy is imperiled by a huge climate denial fraud operation, a huge dark money corruption operation, and a huge court capture operation, which have like 90% overlay between them. So basically it's one big operation. And there is literally nobody who digs more effectively into that operation than the woman who is sitting next to me. And this book focuses on the Supreme Court part, and it opens with John Roberts, who likes to cast himself as the great institutionalist, the defender of the court's moderate and high integrity side, and a person who is above the partisanship of Washington. Any of that true?
No.
Tell more.
Yes. Well, thank you so much, Senator. He's a hero of mine as well, really the champion in the United States Senate on the vital court reforms we must undertake to stop this out-of-control court. But I will answer the question more than just to say no. You know, one of the things that really struck me in watching his nomination and confirmation unfold was how effective he was at this PR that he was spinning to try to convey to the American people that he would be a fair judge, that he would be this umpire that just called balls and strikes. I knew it wasn't true at the time, since I had studied him along with my colleagues on Senate Judiciary Committee before then. But then to see what he's done to America, to our law over the last 20 years, it has exceeded even my greatest fears. of what John Roberts would do in terms of dismantling our rights and rewriting the Constitution.
Go back for just a second to what you were doing there. You were not just in the room, you were an important part of this whole thing. Describe the Lisa Graves role through all this.
Well, the fundamental component of my role is that I am an optimist. That may be hard to believe in these circumstances, but I was working hard for Senator Leahy. I was his chief counsel for nominations. Some of my wonderful colleagues are here in the room, and we were trying to protect the courts after George W. Bush became president in 2001, and I never say elected really at that point, but he became president because of the Supreme Court. Yeah, Bush v. Gore. Yeah. But so we were trying to protect fair courts, and so my job as chief counsel for nominations was to evaluate the people who Bush had nominated, and John Roberts was really at the top of their list, and so I worked with my team to put together memos and work on strategy with the chief counsel of the committee, along with the senator and others, to try to basically slow down John Roberts and other nominees who we thought would be terrible for the courts. So I was concerned. I used to say, now I used to joke, it seems not so appropriate now, but I used to joke that the best thing that ever happened to John Roberts was that Bill Clinton became president, because he could spend the next decade basically trying to burnish his credentials and make friends with big firm partners and try to get Democratic support for his goal of getting on the Supreme Court in order to revise and rewrite our rights. So my role was to help mount the campaign against him. And when he was confirmed to the DC Circuit, I was convinced that he was going to be their nominee for the Supreme Court, and ultimately he was.
And when you're doing that kind of work, particularly when you're a senior Judiciary Committee, Senate staffer with a Supreme Court nominee in front of you, what are those days like?
Well, so I had prepared the playbook basically for 2005 and 2004 for a potential Supreme Court vacancy, but the days before then were, and Christine and others, Jennifer and others in the room can attest this, we were in basically hand-to-hand combat, verbally, in writing. The Republicans were attacking us relentlessly. The Wall Street Journal Ed Page was attacking us relentlessly. They had mounted new dark money groups that came out of nowhere to attack us, to call my boss, Senator Leahy, anti-Catholic, Senator Kennedy anti-Catholic, Senator Durbin anti-Catholic. They just, they were relentless. And so it was...
All Catholics, in case you haven't been keeping score.
Yeah. So they ran those ads in their hometown papers, like full-page print ads. And so there was this big money machine coming after us that was just emerging, and it was, I think at one point I walked out of the office, I'd slept there or worked there overnight, and I'd forgotten I didn't drive, and it was raining, and I couldn't find my car, and then I realized, oh, I've been here too long. So that's what it was like, yeah.
So let's take a little excursion, since you mentioned Bush v. Gore, into Bush v. Gore, because it pops up in the trajectory of the Supreme Court as kind of the original team for a lot of the people who figure into your book and into the whole Supreme Court capture operation. Describe a little bit about the Florida team that went down to Bush v. Gore, and who's famous or infamous now was on that.
Yeah. So it turns out that John Roberts was asked by at least 3 different high-level Republicans to go to Florida to help Bush stop the counting of the votes in 2000. And that included a top person from the George W. Bush campaign, his brother's top advisor, a former law firm partner who was one of his co-clerks, and then Ted Cruz, and a guy who I and others helped make front page news, Leonard Leo. So the right-wing Republican operation, immediately emerged to head down to Florida to stop those votes from being counted. And Roberts was a key component of that. He describes it a bit in his Judiciary Committee forum, but there was more to it in terms of his role, not just, quote, advising Jeb Bush on the process for counting or not counting electoral votes, which now we know a lot more about, but also came back to advise in the oral arguments, which were designed to stop those votes, that recount from happening when the vote was so narrow that, of course, there should have been a recount.
And how many other justices were part of that Bush v. Gore team?
Yes, you won't be surprised to know that Brett Kavanaugh was there and Amy Coney Barrett too. So 3 of the 6 members of the Republican appointees to the Supreme Court were enmeshed in that battle to stop Americans' votes from being counted in 2000. So in some ways, given that, it's not a surprise at what they've been doing to us since then.
So you think, perhaps that these are just conservative judges and justices and that they've just come through a normal process and been selected from various parts of the country. But in fact, there's a huge feeder fountain in the Bush v. Gore political effort to knock out the Florida actual election results.
There is, and there was a reward. There was a reward. John Roberts was in the first set of nominees, the May 9th, 2001 nominees that Bush announced as his first slate because they were preparing for a potential Supreme Court vacancy 1 or 2. But also Ted Cruz went over to the Justice Department in the deputy's office, and as I describe in my book, I had to walk into his office I was a career deputy assistant attorney general in the Office of Policy Development, the Office of Legal Policy, and Ted came in along with this crew of Bush operatives, and so I had to give him the orderly transition in government books, like here's our policy on X and Y and Z. And when I walked into his office one day, I saw this paperweight sparkling in the sun, and he wanted me to sit down. I did not want to sit down, so I sidled over to the paperweight while he was on the phone. I looked down, and the things that were sparkling were Chads in a glass paperweight that said Bush Cheney Florida Recount Team 2000. And I almost threw it out the window on Constitution Avenue. I thought I could end my career at the Justice Department in a real shattering of glass, but I decided to just walk myself out of that office and never forget who these traitors were in terms of their embrace of the idea, that they were engaged in a heroic effort to install Bush in office no matter what the vote was going to be.
You mentioned the dark money groups that popped up to go after Senators Leahy and Kennedy and Durbin as being anti-Catholic. Say a little bit about the scope of the dark money funded court capture operation, both in terms of its duration over time and in terms of its scope in size and breadth.
Well, back in 2018, Evan Vorpal, who's in the back over there and works for me still, he and I were taking a look at this question after Gorsuch was confirmed, and we started with what we thought was the $50 million question, as in who spent $50 million to block President Obama's nominee, Merrick Garland, and to install Brett Kavanaugh, no Gorsuch on that court, and that was as Brett Kavanaugh's nomination was pending. As we continued to dig through connections to Leonard Leo, we were like, it's $100 million from 2014 to 2017 that no one even knows where it came. Well, Leo knows where it came from, but no one in the outside world knew where it came from. And so I actually was having a conversation with Kurt Davies, who's here in the room, and he suggested some options for trying to get that investigated. And so ultimately, the Washington Post looked into it. Bob O'Hara, the late great Bob O'Hara, and Sean Boberg. And when they finished the tally, they tallied $250 million. And that was before the Kavanaugh.
Before it got the Lisa Graves treatment.
Yeah. So that revelation was astonishing. And then more money came in to help Kavanaugh. And then more money came in to get Amy Coney Barrett on the court. And then at that same time, as the Post documented, Leonard Leo paid off his home mortgage 22 years early. Have any of you had that opportunity? I haven't. But he paid that off as Kavanaugh's nomination was pending. And then when the Senate was voting on cloture to close the debate to confirm Brett Kavanaugh with the help of Senator Susan Collins of Maine, he closed on a mansion in Maine with $1 million cash down and a $2 million mortgage. And then after the Post published that story, 2 or 3 months later, he paid off that mortgage with another $2 million. Now, Leonard was working for the Federalist Society at that time. He was the vice president. But because he'd been a volunteer for Trump, he did not have to file any financial disclosures about the sources of those millions of dollars.
And now that whole court capture operation that went from 50 to 100 to $250 million, what's your current number for how much the far right has spent capturing the Supreme Court?
Well, you had a hearing a couple of years ago, and we retallied that figure, and then your team looked at it, and I think the figure at that time was $600 million, but that was before the revelation that an industrialist named Barry Side, who was a longtime ally of Charles Koch, who also was part of this court capture machine, that was before we learned that Barry Side had given Leonard Leo a trust worth $1.6 billion. Over the past 4 or 5 years, Evan and I were tallying this the other day, a couple weeks ago, and I think that he's spent, because when you have $1.6 billion, you have interest on that money that you can spend without spending down the reserve. But he spent down the reserve by $600 million, plus, I think, another $600 million. So he spent probably more than $1.1 to $1.2 billion since 2020 on further efforts to capture the law and expand the reach of this very regressive, repressive agenda.
How many groups, roughly, have been involved in it? I mean, given that some of them are just nominal and just front groups and only names, and yet another group in the same address with other groups. But still, if you want to make a list, would it be more than 10?
Oh, for sure. And actually, Senator Whitehouse has an amazing series on the floor of the Senate with graphics describing this nest of groups. But it's far more than 10, more than 20, more than 30. And then there's some we just don't know, because now that $1.6 billion, that's about $1 billion, the $200 million or more that he's spending every year is being funneled through pass-through groups, and then another pass-through group, so that there's a shell game that makes it hard to say definitively which groups are getting it, but we can see the groups on the right that are surging in money. And in fact, another allied group did a tally showing that most of the groups that participated in Project 2025 were funded by Leonard Leo.
So they really, really blow up when there are big nominations and they want to press people to vote for even very challenged nominees like Brett Kavanaugh. But once you've got your people on the court, they need to be reminded of what it is that they're supposed to do. There's a whole lot of topics. How do these groups communicate with the court once the people that they've fought to get on the court are up on the bench and in their robes?
Well, Senator Whitehouse coined the phrase a flotilla of amicus briefs, and that's what it is. It's a flotilla, like a set of ships coming in and giving the right-wing appointees to the Supreme Court options for choosing this case. They'll have multiple abortion cases that are coming up, or multiple cases on X or Y or Z issue, on the Chevron doctrine or what have you. And so they're basically signaling these groups that are funded by Leonard Leo and Charles Koch and some of these other right-wing billionaires or billionaire trustees are signaling to the court which cases they want the court to take up. And then they do. And when they do, it's a bit, I know there's a whole business here in Washington, D.C. of oral advocates to the Supreme Court who hope that they're going to be the one that persuade John Roberts, Amy Coney Barrett to not do the wrong thing. But basically, when they take that case, they're signaling that they have the votes to change the law in favor of the groups that are part of this racket, in my view. This, I wouldn't call it a criminal racket, but it certainly is an enterprise that is determined to roll back our rights.
Yeah, well, enterprise has its own set of meanings, doesn't it?
Yes, it does. Yeah.
The flotillas, when they come in, say 12 or 15 strong in the average case in which they take an interest, Roberts likes to talk about, calling balls and strikes. So let's use a baseball analogy. How are they doing at their batting average?
Well, they're doing very well. And in fact, Court Accountability, which I co-founded, just released a report this past week about how, to build on what's been covered in the news, about how well not just those amicus groups are doing, but the Donald Trump is doing in these decisions, overturning well-reasoned, factually grounded, legally solid decisions by lower courts in these temporary restraining order cases. And there are also amicus briefs in some of those cases below and coming up to the court. But the amicus, I think the statistic is something like somewhere between 75 and 90%. Like they win since 2020, since they stacked the court, since they fully captured the court and don't really have to worry about having a swing vote to negotiate with. It's just they can just take the mask off and move this agenda forward. Those amicus groups, that flotilla is winning almost all the time, basically.
Yeah. That's my read of it too. They may not win everything that they asked for in that particular case, but they're batting 1,000
Yeah.
in terms of directionality, and they're probably batting 800 in terms of getting whatever it is that they
Yep.
want, including brand new doctrines like major questions
Right.
or undoing Chevron doctrine or things like that. So you've got all the groups that went to work to push for the nominees. You've got the pool of groups out of which these flotillas are sent to the Supreme Court. Is there another effort with respect to where these doctrines all come from, like major questions or like originalism or like unitary executive? Is there a connection there too?
Definitely. Some of the same funders, including Charles Koch, has been at the forefront of moving this agenda forward really for decades to regress the law. And we see that not just through the groups that he directly funds, but also through other groups that he directly funds, like the Federalist Society, and the things that they choose to emphasize while they claim that they don't take a position on anything, while in essence taking a position on a whole lot of things. This major questions doctrine, which I call a theory, is an example of just how extreme and out of control this court is, because they literally invented that frame. They invented, meaning they adopted this frame. It wasn't part of Supreme Court jurisprudence, and they did so as that doctrine theory was kicking around these right-wing groups, and they did so to take down key initiatives of Democratic presidents. So the Clean Power Plan. That was the Obama-Biden administration plan on climate change to take down Joe Biden's efforts to have modest student debt relief. That was these are the type of things where this was, quote, a major question, in the words of this Republican right-wing captured court, that a president couldn't do, even if they had statutory language that was consistent, because that was something Congress was supposed to do first. And yet when this Supreme Court paved the way for Donald Trump's return to the White House with that terrible discredited immunity edict last year, this court has been, you have not heard major questions doctrine probably once from this court, as it has allowed this president to engage in an array of destructive unilateral actions. And so again, like originalism, which really was honed by the Federalist Society and Charles Koch and these other right-wing groups, the doctrines are completely dispensable. They're completely flexible to basically crush progressive initiatives, but to allow the right-wing agenda to proceed.
Yeah. The one thing that I would want to make sure people didn't give the Federalist Society too much credit for is its role in selecting nominees, because Lisa's right. They have never had a formal role. It's never been on their agenda. They've never had a vote. The so-called Federalist Society list that candidate Trump promised he'd pick from in order to get the support of the Koch brothers and others was never approved by the Federalist Society, never on the agenda of the Federalist Society. It was a comfortable name, but I think more accurately, it was the creepy billionaires list, cooked up by the Koch brothers operation, Leonard Leo, Don McGahn, and this was the tribute that candidate Trump was going to pay to the right-wing billionaires who want to control the court, because they knew he couldn't be trusted with a deal unless he'd put it out there.
Yep.
So they put it out there through this list, and then the Koch brothers backed off on their relentless attacks against Trump. The timing works actually quite well.
Yes, that's true. And when you look at the Federalist Society, its history, what you see is it was really created as an attack on Roe. The very first Federalist Society convention was about Roe. Robert Bork was there. Antonin Scalia was there. It was also designed to try to figure out whether there was a way to undo Brown versus Board of Education. That's part of that originalism, this notion of originalism that they were going after. I think they decided at that time they couldn't go after it, but they were going to go after Roe. And then by 1986, just 4 years in, they had so much funding and support, and they were so plugged in to the Reagan administration that they were basically bragging, with the help of funders like Richard Scaife and others, they were bragging that by the year 2000, almost all of the judges that were appointed by Republicans would be Federal Society judges. So they were boasting in 1986 about that. And they, at that time, they did endorse Antonin Scalia for a judgeship on the Supreme Court, who of course turned out to be both an ethical disaster in my view and also someone who was deeply destructive of individual rights.
And the role of the court capture operation, in some people's view, traces back to a very early memo drafted for the U.S. Chamber of Commerce by an interesting tobacco lawyer.
Yes.
Is that part of the saga here?
It is, yes.
The founding moment?
Yes, so you can see the memo by Lewis Powell, who was not just a tobacco lawyer who had worked so hard to try to keep warnings off of cigarettes. He also was the counsel to Richmond and to Virginia in its efforts to evade and slow down the desegregation orders that came out of Brown versus Board of Education. And he was rewarded by Nixon, along with Bill Rehnquist, for a job on the Supreme Court. Powell was rewarded just months after he wrote this memo, this strategy memo, this blueprint for the U.S. Chamber of Commerce about how business needed to be more involved in the courts, more involved in taking over universities or directing their activities. And ultimately, shortly after that memo and shortly after Powell was confirmed, Charles Koch, long before Google, but Charles Koch wrote a speech where he said that the Powell memo didn't go far enough because it didn't exact promises from public universities or universities in exchange for the money that they were going to get. And so he was always going to take this transactional approach. But also David Horowitz wrote a memo for Richard Scaife about how they needed to take over the law schools and really create this pipeline that Scaife ultimately funded that became the Federal Society.
So a lot of time behind this, a lot of money behind this, dozens of front groups through which it is implemented. How is it that my side of the aisle got surprised? I mean, this was a covert operation, but not really.
That is a great question. I will say Christine Lucius and Lisa Klepper and Jennifer Duck and I were busy putting into the congressional record the notations of how many of these Federal Society judges or people were being nominated to these appellate judgeships. So we were making an early case for people to understand what was happening. And in fact, the Democrats, after that 2002 midterm when Dick Cheney and Bush ran these ads attacking Democrats for supposedly being in favor of Osama bin Laden, when they took the midterms in 2002, no one thought that the Democrats would stand up to this president. But that team of staffers, along with the senators that we worked for, really understood in that moment how important the courts were and how important the Supreme Court was. And they mounted filibusters of these Bush nominees, the most extreme, and tried to block some of them and succeeded in blocking some of them. And then the 2004 election happened. And some Democrats sort of decided to caucus with the Republicans in allowing that to go through. And so, I think that you, since your presence in the Senate, Senator, have been just at the forefront of shining a light on this. But I think some members, and I don't want to be disrespectful, but some members have been living in a different world in terms of thinking that they could just have comity and be colleagues with people who are actually determined to capture the court and destroy our rights. And in fact, the way this court has upended our election laws and our democracy is truly astounding. And I think some members just kind of kept hoping that maybe if they were generous, that they would be treated fairly in return, like when Merrick Garland was nominated.
Yeah. Well, let me throw out one number to put some context around how it makes sense to spend, let's say, $600+ million to capture the court. The International Monetary Fund looks at how big the subsidy is for fossil fuel using the well-established economic doctrine that negative externalities, the poisoning, the pollution, all of the harms, should be baked into the price of the product. That's how economics is supposed to work, even according to Milton Friedman. So That number for fossil fuel every year in the United States alone is $700 billion. So if a court will protect the fossil fuel industry's ability to pollute for free, it is a $700 billion annual value, and even I can do the math of what spending $700 million means when you're protecting an annual 700 billion. So let's talk about, since we are in politics, I am anyway, let's talk about some of the political cases. Let's talk about Citizens United and dark money. Let's talk about, particularly with the Louisiana case coming up, Shelby County and the Voting Rights Act, and Rucho and gerrymandering. Since we're in mid-gerrymandering, how effective has Citizens United been at corrupting American politics?
It's been terribly, terribly effective. And I do want to just say before I jump in there, the return on investment, as you point out, on trying to capture the courts is massive. And they're not doing it because they want fair judges. This effort to put Roberts forward, as I describe in my book, how there was no more suitors campaign against Roberts. And then the second he was confirmed, when Myers was nominated, all of a sudden Robert Bork and the others were like, wait, no more suitors. Because Roberts was never going to be a suitor. He was never going to be someone who just followed the precedent. They wanted gunners. They wanted people who were going to be sure votes. That's what Roberts and Alito are. That's what the Trump nominees are. That's what Thomas is. And so this is a captured court. And what that means is they are not fair. They're not acting as fair judges. They were chosen not to be fair. And in the area of elections is one of the areas in which they've been most heavy-handed in terms of really putting their thumb or their fist on the scale of justice in favor of the party that appointed them and the movement that they're part of. And so Citizens United is, I think has done grave damage to our democracy in terms of the money that it has unleashed in our elections. And it not culminated because we're not done yet, but with the notion that someone like Elon Musk could spend more than anyone has ever spent and become for a period a co-president to buy himself in essence that role. That is a result of that Citizens United decision and more. And then we should talk about Shelby, but can I just share one story briefly about Citizens United?
Totally.
Which is, what we describe in the book and what Heidi Presbilla detailed in one of her reports for Politico is how Jenny Thomas received a gift of $500,000 to stake her Tea Party group, Liberty Central, that she was going to launch after the Citizens United decision was issued. She received that, basically promised to give the money to her as the case was pending, and Thomas didn't recuse himself. It was a 5-4 decision. And had he recused himself, it would have been a 4-4 decision that would have upheld the lower court. But he not only sat on that case and issued that illegitimate ruling, he also issued a concurrence in which he said disclosure would violate First Amendment rights. That's how audacious and corrupt this enterprise is.
So Citizens United launched unlimited money into our elections from special interests who had the money and the motive to do that. And it also said, kind of as a fact-finding, not a legal determination, as a fact-finding, it said, you don't have to worry about corruption because everybody's going to see where all this money comes from. It's all going to be transparent. How did that work out, and what has the court done about that since?
Well, you can blame Justice Kennedy for that because he wrote that opinion, and he had the fundamentally false belief that disclosure was already going to be happening, even though there was not a Disclose Act, and the Republicans have year after year blocked every effort to adopt a Disclose Act just to get the baseline of, if you're going to spend money around an election, we're going to assume that it's related to the election, and you have to disclose who's giving it to you. And the way it's dark money is that it's dark, right? You don't know. You can trace some things. We do a lot of time tracing, but you don't know, in contrast to the federal election rules where there's a limit, at least for the time being, on how much a particular person can give to a candidate or to a party. Sort of a limit, I suppose. And you have to disclose who's giving the money. But in this area, there is not. And so the decision was fundamentally flawed on the legal basis in terms of rewriting our First Amendment to say that not just Buckley versus Vallejo, but Buckley versus Vallejo on steroids, that money is speech. But then this notion that it would all be seen, and so it's not corrupt, was the opposite. And the other members of the court, I'm sure, knew that. Certainly the parties who were arguing for Citizens United knew that it would not be disclosed. In fact, you can see papers that were leaked in that time frame of 2010, 2011, 2012, where groups were saying, I think the American Traditions Group, for example, were saying to their donors, now you can give us unlimited money and no one will ever know that you helped get this seat, you helped win this seat.
So they knew something about the enforcement by the court
Yes.
as well. So let's go on to Shelby, which has its own false fact, which is that
Yes.
everything's different now.
Yeah, so this is another area in which this court, this Roberts court, is not behaving like a court. So in traditional jurisprudence, as many of you in the room know, the lower courts make factual findings, and the job of the appellate courts is to defer to those factual findings unless they're clearly erroneous or plainly erroneous. There's a variety of standards, but they basically amount to clear error. Because the Supreme Court is not a fact-finding body, it is supposed to defer to the findings of lower courts, and in this vaunted notion of separation of powers, they're also supposed to defer to the findings of Congress. In the area of voting rights, under the 14th Amendment, Section 5 of the 14th Amendment, it's plain that Congress is expressly given the power to enforce the voting rights that the 14th Amendment begins to secure. And then in Section 2 of the 15th Amendment, again, Congress is given the power to enforce that grant of the right to vote to African Americans right after the Civil War, African American men right after the Civil War. And so Congress made detailed findings in 2006, 2007, reauthorizing the Voting Rights Act a year ahead, so in 2006, ahead of schedule, after thousands of pages of factual findings saying that we need these pre-clearance provisions for the Justice Department. We need these provisions to protect against the right to vote from being degraded and diluted. But John Roberts took it on himself in 2013 to assert things had changed. Obama was president. And so therefore we didn't need a pre-clearance provision. And immediately as that decision was being announced, states like Texas and others were announcing how they were going to be enacting measures to make it harder for Americans to vote. So everyone knew that was the outcome, and Roberts didn't care because he's been devoted to assailing and undermining the Voting Rights Act from the very beginning of his legal career.
And Section 2 is on the Supreme Court's docket right now in the Louisiana case. Describe what Section 2 protects a state that has a minority population that it does not want to see turn up in Congress do.
Yes. Yeah, so in the Louisiana case, the Calais case, there are voting rights experts in this room. I can see some of you over here. This set of cases is a case where this court is taking this by choice and taking it now. And what they're considering doing, as you could hear from the reports of the oral argument, is striking down Section 2 of the Voting Rights Act, one of the most fundamentally vital changes to American law as part of what I consider to be the most important law Congress ever passed, the Voting Rights Act of 1965, which was purchased with the blood, sweat, and tears of generations of Americans who fought for the right to vote to be real. And Section 2 is, in fact, the part of the Voting Rights Act that John Roberts cut his teeth on at the Justice Department, trying to protect his boss's decision, a decision by Bill Rehnquist and other Republican appointees, to limit the ability of courts to consider the effect of a change in voting rights in jurisdictions where there'd been a history of limiting voting rights. John Roberts spent hundreds of hours trying to stop that case from being overturned, and it turned out, when I looked more closely at his record, that it was Bill Rehnquist who called Ken Starr at the Justice Department to ask him to hire John Roberts to the top of the Justice Department to be the special advisor to the Attorney General. And John Roberts was given the job of being the point person assailing this effort to overturn this Supreme Court decision. And John Roberts had no experience in voting rights except for working for the most anti-voting rights justice on the Supreme Court, Bill Rehnquist. And so right now, John Roberts has a chance to win what he lost in 1981-82 when he was the key advisor working hundreds of hours to block Congress. Now he can use his power on the court, and he looks like he's poised to do so along with Kavanaugh and the rest of the gang, to overturn and declare that we cannot have these minority majority districts in the South where there's a documented history of white legislatures trying to dilute the vote of Black Americans.
And the flip side of that would be that it would allow a white majority state legislature to draw the district lines so that no Black person, even in a 30-40% population, Black population state, could ever get elected to Congress.
That's right. And in fact, in Louisiana, in the cases before the court, Louisiana has a population of African Americans that's more than a third of the state. And this white legislature drew maps that were 5 white majority districts and 1 Black majority district. And so already it's disproportionate and diluted. And what this court wants to do, it appears, is to say that they can't even, that a legislature cannot draw a district to secure representation for Black Americans while they're securing ample representation for white Americans in Louisiana.
So the last one, Rucho, the gerrymandering case that never was because of another false fact. How does this close out the trifecta of democracy damage?
Yes, so this, the Rucho case is a case, as you know, about redistricting, about map drawing. It's related to these core issues of the Voting Rights Act. And that was a case along with another series of cases, Brnovich and more, where the Supreme Court basically tried to take the federal courts out of the role of policing these maps. And in essence said that the federal courts were not going to play a role, but they said, no, don't worry, the state courts can. State courts can still protect maps. And they said, don't worry, because you can also protect against racial gerrymandering. And then last year, in the South Carolina case involving the NAACP in South Carolina, there was a case that the court took where the white Republican legislature in South Carolina drew a map to protect Nancy Mace's district, the first district of South Carolina, pardon me. And it bleached out more than 20,000 Black voters from the Gullah community out of the district they'd voted in for generations in order to secure her seat. The lower court findings were that this was obviously a racial gerrymander and that it was illegal under the Voting Rights Act and under case law, and that 3-judge panel below ordered the maps to be redrawn. And this Supreme Court sat on that case until after the primary to basically allow the primary to go forward with maps that were in violation of voting rights in America. And then ultimately, the Roberts Court ruled that they could go forward, these maps could go forward because it was targeting Democrats, not Blacks. And so it wasn't really a racial gerrymander as long as it was a partisan gerrymander, which, by the way, was exactly the argument that Bill Rehnquist made about his voter suppression efforts in the Black neighborhood of Bethune in Phoenix back in the 1960s, when he was like, I'm not targeting the Black neighborhood, I'm targeting Democrats. So we've come full circle. And in fact, that was also part of the argument before Roberts in Section 2, in that Section 2 case and in 1981, 82, was this idea that you couldn't look at the effect. You could only stop something if you could show a racist intent expressly, out loud racism.
She knows her stuff, doesn't she? So let's take a few audience questions, and if you wouldn't mind, please do everyone a favor and make sure it actually is a question. And
over here.
And here we have somebody already.
So I was a classmate of Hillary's at Yale Law School, and I was so disgusted in 1986. I left the federal government. I was the staff attorney at the Environmental Protection Agency and went to medical school. I couldn't bear counting angels on the head of a pin. Talk about all of these orders in which the Supreme Court reverses injunctions from lower courts who've done much better than I expected, frankly, at stopping illegal orders from Trump. They stop the injunction so that the Trump orders can go forward. Do these things have precedential value even when there's no opinion, just an order?
Well, they're asserting that they have precedential value because
know.
they've been criticizing lower courts for not imputing the reversals to come, basically.
Exactly.
But I know that the Senate has been tracking. The Senator has been tracking this
But
closely
at
as
the
well.
same time, some of the justices have also been saying publicly, these aren't precedential, and everybody should just calm down and wait until the actual decision comes out. So they're playing both sides of the argument.
Yeah, and when I look at this, and I was a litigator a long time ago, and I love civil procedure and the procedural rules. I'm that type of nerd, basically. But the rule in short form, the rules are that you can get a temporary restraining order, not easily, but if you show a substantial likelihood of success on the merits,
Exactly.
meaning the statute is in your favor, or the precedent is in your favor, or the Constitution is in your favor, and you can show that if this action is not blocked temporarily until the merits are decided, that you will suffer irreparable harm. And so what's happened is that below, the lower courts, these trial courts, have found in detail factual findings supporting that irreparable harm to the plaintiffs, and that the law is on their side. And this arrogant, out of control Roberts Court has acted in defiance of those findings in order to mow down laws to help Trump continue taking actions as if he's the only one who suffers irreparable harm if he can't do whatever he wants, which is, in a way, not a surprise after the mask has fallen with the decision last year on immunity to give Donald Trump counter-constitutional, anti-constitutional immunity from criminal prosecution, even though John Roberts pledged in his confirmation hearing that he agreed, which everyone should agree, that no one is above the law.
Right.
And then when it mattered most, he broke that promise. And so not only did the Supreme Court pave the way for Trump's return to power and signal to some of the American people that he did no wrong and could do no wrong, but now in case after case, nearly 20 rulings, this court has basically said, and he's not doing wrong, now he can proceed.
Next question.
Ms. Graves, could you expand on your proposal for reform of 20-year term limits for justices beyond the practical problems of getting the Constitution amended? If you believe in a theory that the rules, a Rawlsian theory of justice, that the rules should be neutral as to the outcome, how does that help progressive, democratic folks? And then Senator Whitehouse, there seems to be a question about what is the nuclear option here. Specifically, there seems to be a change in tone at the Justice Department where they will not obey orders from the courts, not necessarily even the Supreme Court, appellate courts and lower courts. If you could address that. But Ms. Grace, first on the reform, and then Senator on the other issue.
Well, there are a number of reforms that I think need to be examined, and the term limits is one of them. I talk about some of them in the book and hope to talk a lot more about them in the months and years to come, because we absolutely have to build the momentum for reform, or this court is going to continue to dismantle our rights unrestrained. So term limits, the way that's described, at least in some of the proposals, is it's a neutral application. 20 years right now would remove at least 3 of the justices, and others would be immediately in queue. But there are also proposals to make sure that every president has an opportunity to have nominees, so that you don't have this rigging of the system where Republicans only retire under Republicans, and extend a multi-year sort of bounty, for example, where the Republicans had 11 justices appointed in a row during my lifetime, during our lifetimes almost, for most people here. And then they only retire when there's a Republican, and so it just kind of keeps the fix in. So there are a number of proposals, I think, and I think they are really neutral in that Rawlsian sense. They're good government reforms to protect us from having a court that isn't behaving like a court at all, and in fact was designed by the court capture scheme to not behave like a court, but to behave like an arm of this apparatus.
Yeah, and the question of deliberate violation of court orders, I think, is a very real one. A very senior individual at the Department of Justice had a meeting with lawyers about the overnight deportations, during which he told the other department lawyers, you've got to be ready to tell courts to F off, because we're under direction to get these people out of the country, and we can't mess with that. In my line of work, people look at corroborating evidence, and like within hours, the text chain of the people who were in that meeting were corroborating that that was in fact said, because naturally there'd be a reaction. I'm sure that's the first time any person at any senior level in the Department of Justice in the history of the country has said, well, we got to be ready to blow off court orders if they don't come down the way that we want.
Yeah, I mean, that
And
not
I
even
think
Nixon's.
some of the flinch about these so-called shadow docket rulings is actually the court being frightened of a challenge with Trump. They don't want to give him the chance to roll them that way, so they just pre-roll. And then we'll see how the decision comes out. Maybe they bought some time and all of that, but it's not very. It's an unpleasant moment.
Yeah.
Yeah. Next.
So that might have been my question, but let me ask it a different way, and then a second question if you've already answered the first. So let's say I'm the next Democratic president in the White House, and you're my advisor. What would you advise? What's the range of options? So that's question one. Question two is, what is the threat to the midterms? Elections are controlled by states, but if somebody challenged an election and it went to this Supreme Court, what's the threat of somehow not having a fair election for this set of midterms?
Well, on the first question, I'm going to say buy the book because there is a chapter in the epilogue about a series of reforms, but they're not all the reforms that I think we should be looking at. I think we need to really take a bold view, and in fact, Court Accountability and the group that I helped co-found is looking at how can we really think big about what needs to happen to restore our freedom. So not just court reform, but substantive reform, like the Voting Rights Act reforms, repairs to what the damage this court has done, but not just repair to go backward, but to think expansively about who America is, because the Constitution, in theory, is supposed to reflect the dreams of the American people, the aspirations, the struggles, and try to settle some of those issues, which this court is busy unsettling and revising the law. So I think I want us to have an amazing series of conversations about the reforms we need to repair our society. And the court reform is essential to that, because if we don't reform the court as part of that, they will continue to strike things down. But let me pass the baton over to the senator.
I just add that a proper ethics code wouldn't do any harm either.
Yeah.
These are literally the 9 people in all of government in the United States of America who, if a legitimate challenge is made that isn't just dismissible as frivolous, if a real challenge is made to their ethical behavior, there is no neutral determinant of it. And the Supreme Court says, well, that's because it's impossible. It's so difficult because we are the Supreme Court. So what are you going to do? Well, all 50 states also have Supreme Courts. And they've got the exact same situation with respect to their lower courts and their supremacy and all of that. 50 for 50, they figured it out without a problem. So this is really a question of will, not a question of how.
Yeah.
So the second question is, what is the threat to the midterms from this president and this Supreme Court? How serious a threat is there?
I think the threat is pretty serious. I think they're going to try everything they can. I would not be surprised if these efforts to go and fight crime with the National Guard and to put a lot of ICE agents onto streets is to kind of inoculate us against that image, so that when that's redone on voting day, we've gotten more used to it from a point of view of crime fighting and immigration enforcement. And when you look at the way they're manipulating the gerrymandering rule right now to win that election, that's supposed to happen every 10 years. This, do it whenever an election's coming, is a new phenomenon. Nobody did that before. So there's a lot that's being bent towards an election success in November, despite the will of the voters, not to implement the will of the voters.
And I'll just add while the next person comes up that in my personal capacity, not my organizational capacity, I remember Karl Rove talking about getting a permanent Republican majority. That has been their aspiration for more than 20 years. They have a court has been willing to bend and break the rules to help them get there. And it's sort of like all bets are off with what we've seen unfold over the last 6, 7, 8, is it 9 months now? It seems like hell. Like in dog years, it's longer. But that's why in the opening of my book, I quote one of my other heroes, Frederick Douglass, about how the amount of injustice that will be allowed is the amount that we will tolerate. He said it better than me.
Go ahead.
Thank you. Thank you both so much for being here and doing this. Lisa, to start the conversation, you said that you are an optimist. And so I'm wondering, not to state the obvious, it's a little hard to find optimism these days. And not to be rude, this conversation was a little heavy. So I'm wondering where you both find your optimism and where we can find optimism both for our democracy and what we can look forward to and do ourselves.
Well, Bex, thank you so much for that question. Well, first of all, I'm optimistic by all the people in this room, not just because of my book, but like my tribe is here, and I just feel so grateful for all the love in this room, but not just like, our connection, the folks that I know, but also your connection to what America can be and should be, and that you care, you still care, that we still care and we're not giving up. And so I draw my inspiration from the amazing movement leaders that have come before me who faced extraordinary odds. The women's movement, the civil rights movement, 100 years of civil rights movement, and then ongoing after 1965 to continue to try to keep things from being ripped away. The fact is that things aren't settled in the way that we would like them to be, or in the way they actually should be under the law if the court were deferring to the findings of Congress on the Voting Rights Act, et cetera. We have a moral obligation to take every lawful measure we can to protect our rights and the rights of our fellow citizens and to expand those rights. And we cannot solve that problem in this term with this Congress and this president, but we cannot give up and give in, or we will never solve this problem. And the people who we come from, people who came here as immigrants or people whose families came out of slavery, they did not, as a whole, give up. They did not see daunting, outrageous violence and say, oh, okay, we're just gonna have to live with this. We come from a powerful part of the American society that believes in great ideas and in our fundamental equality as human beings. And like hell, I'm gonna give up this fight ever.
Follow that.
Plus, think how good it will feel when we win. And we know in our hearts that we were not summer soldiers and sunshine patriots, but we delivered this. Last question, and then we'll get to signing books. You've got it. Make it a good one.
Hi, Mr. Steve Bannon made a grand announcement last night, I think, that they figured out a way to have Mr. Trump run for a third term. How serious is this? Do you see a real legal way of doing this?
I think it would be illegal plainly under the Constitution, but we've now seen a court decide that the insurrection bar, doesn't apply. We've seen a court invent immunity out of nothing, where the Constitution expressly says the opposite, that a president has a duty to faithfully execute the Constitution, or the laws, not once but twice, and the oath is exactly that. So this court, I think, cannot, in my personal view, be trusted to decide these issues fairly. 2 years ago, even with what I know about the court, I would have thought perhaps that's a bridge too far. But after upending our entire constitutional system of checks and balances to basically have John Roberts be the kingmaker, making Trump into a king or a quasi-king, and the decisions we've seen so far stopping lower courts from stopping him, I don't know what this Supreme Court would do with that question if it even got to the court, if they didn't just dictate that he was going to stay because Bannon and the gang said so.
All right, one more last question, and then we'll wrap.
Okay.
Sorry. I'm curious what you do about the precedent being set by these kind of John Yoo style OLC memos authorizing strikes without any ability to have oversight over them? And how do you actually undo the precedent that's being set by them for future administrations not to be able to have the same tools in their tool set?
Well, the question was about OLC, Office of Legal Counsel memos within the Department of Justice, which are kind of the internal guidance. There's a whole book to be written on the decline and fall of the OLC. And unfortunately, I was there for its worst moments when they wrote the OLC memos allowing torture based on Medicaid laws and allowing warrantless wiretapping. So OLC has really become a very dismal tool, political tool of the White House in the Department of Justice. And I actually think at this point it's so discredited we should scrap it, and that each of the operating sections of the Department of Justice, the criminal division, the civil division, the antitrust division, should have a person in there who answers general questions. The other thing they do is they keep them secret. So it's really hard to dig through and figure out what they're doing. So it's a real nest of, it has been a real nest of mischief, and because it has not, in my view, been properly cleaned up, it remains a real liability for all of us.
And I guess I would add, I'll add an answer and then a bit of a story if you'll indulge me. So I don't know why. I think Congress should have its own Office of Legal Counsel. Why should it defer to what the executive branch thinks should be done? When I was at the Justice Department, one of the goals was basically to maximize executive branch power. That comes at the cost of Congress, and it could come at the cost of the courts. An office at the Justice Department is not a neutral party, and in fact, it has previously been led by people like Bill Rehnquist, who wrote all sorts of memos that were awful, including the idea that a president could declare martial law in response to a May Day protest. Nixon didn't. Instead, he sort of ordered people to be beaten, or if you spit, they hit, something like that way back when. OLC it's an opinion, and those opinions that are immoral and contrary to fundamentals need to be repudiated, and the people who push for those measures need to be held accountable for them. And then the story is when I was at the Justice Department in the Office of Legal Policy, the Office of Policy Development, we were regularly at odds with OLC. And so at one point we had buttons made up, and I got the buttons printed that said, just because it's constitutional doesn't mean it's a good idea. And so, they say, oh, you could do that. And we would say, but you shouldn't. And we need more people to say, you shouldn't.
One last interesting piece on OLC is that they will issue a decision, and then the United States District Court for the District of Columbia will say that theory is bogus, that is not the law, and we reject it. And then that decision will be upheld by the Circuit Court of Appeals, and OLC will say, actually, nah, we'll stick with what we said, as if they were a court.
Right.
And that the only authority that will correct their errant decisions is an actual United States Supreme Court opinion. That's how grandiose they have become about their own judgments and how set they are in their ways. You can see I love them.
I just want to thank you, Senator, for doing this with me.
Happy to do it, Lisa. Thank you for all your wonderful work, culminating in this great book. And Lisa will be signing up here, right?
Thank you.
We good?